Hey everyone, this is Chris Clark with discgolf.law, and I'm coming to you today to talk about Prodigy's lawsuit that they have filed against Gannon Buhr. On February 15th, 2023, Prodigy Disc Incorporated filed a lawsuit against Gannon Buhr, and I want to talk about this lawsuit as much as I can and what led up to it. Most of what I know about this situation comes from conversations that I've had with various people, but really primarily on the publicly filed court documents. Gannon claims that he started expressing his concerns and dissatisfaction with his Prodigy deal sometime around mid-2021. In January 2022, he signed a new deal with Prodigy, a 2-year deal. And Prodigy says that they were not aware that Gannon was upset with his Prodigy relationship until Gannon's mom contacted Prodigy in November of 2022 asking that Gannon be released from his contract. Prodigy declined that request, but they did offer to renegotiate the terms of his deal. On January 13th, 2023, Gannon emailed Prodigy, citing multiple ways that he believed that Prodigy had materially breached his contract. And so that's really where I want to start, is with that January 13th email from Gannon to Prodigy. In that email, he stated that he had been expressing his concerns about Prodigy for over a year and a half. And he said that Prodigy had a pattern. They had consistently been making promises to Gannon that had gone unfulfilled. Gannon said he had been patient and that he had been loyal, but that he wanted to raise some issues of concern with Prodigy. Number one, Gannon believed that he was entitled to a commemorative disc celebrating his 2021 achievement as the PDGA Rookie of the Year. His second concern was that he had not been receiving regular sales reports relative to his Prodigy discs on which he is entitled to be paid a commission. He complained that he did not get to choose what his signature disc was. He made some fairly specific allegations about the poor quality of Prodigy's discs, and he phrased it in such a way that it was not him that only had made these complaints, but that he was hearing those complaints from others that he knows and reading about a lot of those same complaints online. He also claimed that he was not paid certain bonuses that he was earned and that he was entitled to be paid under the contract. And so with these issues, Gannon said, look, I want to give you 30 days to correct this. In legal terms, we call that giving someone 30 days to cure a breach. There is some cure language in his contract regarding his 2021 Rookie of the Year discs, which according to Gannon, he was supposed to receive in early 2022. He said that Prodigy had promised him 2 different discs and that he had sent a mock-up of one of the discs over to Prodigy. According to Gannon, no disc ever materialized, and that cost him, according to him, a lot of money that he could have made because he suspected, probably correctly, that a lot of people would have liked to have bought those discs. He gave the example that in the previous year, Isaac Robinson had received Rookie of the Year, Isaac being another Prodigy-sponsored player, and that Prodigy had released Isaac's Rookie of the Year disc in January, the year following his being awarded that honor. Relative to Gannon's request for royalty statements, he said that he had requested them numerous times, they never came, and then finally they ultimately received a royalty report in January 2023, but Gannon is not convinced that it's correct partly because the report appeared to contain sales data for Luke Humphrey's disk, which obviously would not be relevant to calculating the amounts owed to Gannon under his contract. Regarding Gannon's complaints about Prodigy disk's quality, he gave some specific examples. In particular, he mentioned the PA3, which I believe is the putter that he likes to use. It is Gannon's claim that Prodigy has switched molds. And so a PA3 that someone might have purchased a couple of years ago versus something that they would have purchased recently or now, they're completely different molds. And so Gannon felt that inconsistency was a problem and could have affected sales of those discs. He also had numerous examples of inferior quality. He mentioned that the flashing on some of the Prodigy discs that he received to be used at a clinic that he was holding were so bad that it made a sharp edge on the edge of the disc to the point that it could have cut someone's hand. And so many of those discs that he was provided by Prodigy, he elected not to use at the clinic for that reason. Prodigy's non-fulfillment of these promises that were made to Gannon outside the confines of the written contract are a lot of the things that Gannon is complaining about, and frankly that we have heard from others close to Prodigy over the years as being a problem. Prodigy responded to Gannon's email by offering him a new contract that would, according to Prodigy, have quadrupled the compensation package of his current deal. But Prodigy didn't hear a response back from Gannon to this new proposal. Prodigy on February 7th, 2023, had their attorney respond to Gannon's previous email message. It first said that Prodigy values its relationship with Gannon Buhr, and therefore they were choosing not to respond to all of Gannon's allegations because they didn't want to generate further hostility between the parties. This is perhaps a technique or strategy that Prodigy's attorney was using to avoid responding to some of Gannon's allegations. And the reason that I believe that is they went on to say in the very next paragraph, this is coming from Prodigy's attorney, they essentially accused Gannon of lying about the quality problems with Prodigy's discs as an excuse to avoid fulfilling his obligations under the agreement. Doesn't sound a lot like language one would choose if they were trying to avoid generating further hostility between the parties. Their main defense was that, look, what these issues that Gannon raised, none of these amount to a material breach of Prodigy's contract with Gannon, and therefore they don't qualify as an event that would trigger the ability to terminate the contract. Prodigy's attorney went on to say that the commission report that they provided to Gannon in January of this year, 2023, was correct. They said, yes, there was a clerical error on there that had some of Luke Humphrey's disc sales, but it was an oversight. And even so, it didn't affect the amount of the commission that Gannon was owed and that Gannon was paid. The letter from Prodigy's lawyer did go on to threaten a lawsuit if Gannon were to attempt to breach the contract or sign with another sponsor or, violate any of Gannon's obligations under the contract, which they went on to remind him include you're not permitted to disclose the financial details of your contract, and any offer to Gannon from another manufacturer would need to be disclosed to Prodigy, and Prodigy has the ability to match that offer. On February 7th, 2023, Gannon's lawyer responded to Prodigy's lawyer's letter by saying, among other things, that Gannon is hereby terminating his contract with Prodigy. On that same day, Gannon also made a video which he posted to his Instagram account stating that he was leaving Prodigy. 2 days after Gannon's Instagram video appeared, Prodigy made a number of filings in federal court in Georgia. One was for a temporary restraining order and preliminary injunction, and the other was a lawsuit against Gannon alleging breach of contract. So let me address each of those two filings one at a time. Prodigy requested that the court hold an emergency hearing immediately based on Prodigy's position that if Gannon were to breach the contract or fail to live up to his obligations under the contract, it would cause Prodigy immediate and irreversible harm as soon as February 16th, 2023, which was the next day. That date also happened to be the date of the Disc Golf Pro Tour Industry Conference Pro-Am, in which Gannon was scheduled to compete and in which he did participate. Incidentally, I was there. I was at the Pro-Am. Gannon was on the card right behind mine, and I was able to observe that he was not wearing Prodigy apparel, but he was throwing Prodigy discs. What is a temporary restraining order or preliminary injunction? They are related types of filings that are emergency measures that would prevent a party from doing specific acts while there is underlying litigation that is ongoing. It's an extraordinary measure to preserve the status quo until a trial can be had on the merits of the case. And when they are granted, they typically are very short in duration, and they're available only when there is an immediate harm and irreparable harm is about to occur. Prodigy went and they said to the court, look, we have a player under contract. He's going to be playing as soon as tomorrow, and it is going to cause us immediate and irreparable harm if he is out there not fulfilling the obligations of his contract, which include wearing Prodigy apparel and throwing Prodigy discs. The court did not grant Prodigy's motion. The second filing that I wanted to talk about is Prodigy suing Gannon for breach of contract. The allegation is that Gannon breached the contract by attempting to terminate it. Prodigy is also asking that Gannon pay Prodigy's attorney's fees. There is language in his Prodigy contract that allows for that, and so Prodigy is saying, hey, if we win, we expect Gannon to cover our attorney's fees. I've looked through Gannon's contract. His contract is interpreted under Georgia law. A contract should be enforced accordance with the terms that were negotiated and agreed to by the parties at the time that the contract was formed. So to the extent that there is a written, signed contract that exists, the courts will enforce it according to its reasonable and logical meaning. Once the contract is entered into by the parties, the written document is the best evidence that we have of what the parties' intent were and what they were intending to agree to. Any inconsistencies or ambiguities in a contract under Georgia law tend to be construed against the party that drafted the contract. And in this case, Prodigy drafted this contract. So I'm not saying there necessarily is any confusion or ambiguity in the language of the contract. There might be. If there is, that's not good for Prodigy because the interpretation by the court will be in Gannon's favor. More importantly, however, Georgia courts will not consider evidence other than the written language of the agreement itself. It's what's contained inside the four corners of the contract. That's what they call it, the four corners rule. Generally speaking, parties can't seek to add new or different terms that aren't contained in the written agreement. That is something called parole evidence. This parole evidence would be evidence outside of the written contract, but that is related to the subject matter of the contract. That is relevant because much of what Gannon provided to Prodigy as evidence of Prodigy making promises and then not fulfilling them is parole evidence. Text messages, emails, Zoom calls, verbal testimony. None of that is likely going to be admissible in demonstrating an agreement between Gannon and Prodigy. Gannon's attorney, in his letter to Prodigy, suggests that the contract or parts of the contract are poorly drafted. I've seen the contract. I'm going to withhold my opinion on that. But one thing that everyone can agree on, it is permitted to terminate the contract based on a material breach. And so some of what this case is going to turn on is whether a material breach occurred. Prodigy says no material breach occurred of this contract, and even if it did, we cured it within the 30-day period that we are allowed based on the contract language. For example, Gannon had said, hey, there's a couple of bonuses that I'm entitled to, one based on PDGA rating and one based on PDGA points. Gannon hit those targets, but he was not paid the bonuses that he was entitled to. Once he notified Prodigy about that, Prodigy paid those. So that's an example of where Prodigy had slipped up and not fulfilled an obligation under the contract, but Gannon notified them and they fixed it. And so, at least with regard to that point, that should be resolved. So why do players and manufacturers even have written agreements? We've seen in recent years players walking away from contracts, and certainly it can't be the case that a player should be able to just walk away from a contract with a manufacturer anytime they want. It also can't be the case that the manufacturers can fail to uphold their end of the bargain with no consequences. And so, we have these written contracts because a carefully drafted, a carefully written contract can go a long way from avoiding these kinds of disputes and avoiding the time and headache and distraction and expense of a lawsuit. I was just at the Disc Golf Pro Tour Industry Conference last week, and I had conversations with multiple individuals and companies about how poorly drafted many of the contracts still are in our industry. And I think the timing of this lawsuit by Prodigy against Gannon hopefully will be a cautionary tale for those of us in the industry, as a reminder that, hey, the dollars that we're talking about now are significant enough that a well-written, well-drafted, and yes, sometimes long contract is good for everybody. I can tell you, having worked in a number of other industries, the contracts that are being used now in disc golf are relatively short. And the reason that we have long contracts in many other industries, and I suspect we'll have more and more within the sport of disc golf, is they help to avoid these costly mistakes and disputes that none of us want to have to deal with. In the court documents filed by Prodigy, a number of disc golf Prodigy Gannon related memes showed up. They're actually screenshots of a number of them pasted into these court documents. I think I know why that was done. I doubt those are going to have much relevance, but it was a little odd and surprising to see that. So what happens now? I read recently, it was from the American Judges Association, 97% of civil lawsuits that are filed are resolved in some other way other than a trial. That makes sense because judges and juries do unpredictable things. I'm just trying to imagine having to explain a lot of the concepts and nuances within disc golf to a judge or jury that just has no experience with the sport. I think it's just way too risky to leave the resolution of something like this in the hands of, I'm sure, good intentioned and smart people, but just without any kind of knowledge or understanding of the sport. So for those of you that are hoping for a Johnny Depp versus Amber Heard style multi-week televised trial, I think there's almost zero chance that that happens. I think it is highly likely that this gets resolved, I suspect, fairly quickly. I doubt we will see many more, if any, court filings in this matter. Could be wrong, obviously, but my experience tells me that this is likely to get settled. I've seen many people make the point on, social media and other places that, hey, when Gannon signed this contract, he was a minor, so the contract's not enforceable. If Gannon had been the only person that signed the contract, that might be the case. Prodigy was savvy enough to have his mom, his legal guardian, also sign the contract. And so I think it's extremely likely that the contract would not be voided based on unenforceability due to Gannon's age. In terms of the merits of the case, I don't know, but I think Prodigy might be able to prevail in this court. They might be able to win this legal battle. But what does that do in the court of public opinion? What damage might this do to Prodigy's reputation and image among its customers and among other professional players? This again underscores, I think, the value and importance of trying to resolve disputes like this without resorting to litigation. There's a lot of negotiation to be done, and you can hire a private mediator and you can have a third party come in and help mediate this dispute, and it can all be private and nobody ever has to know about it. In this case, an approach like that might have saved Prodigy's reputation a little bit. Prodigy might be saying, hey, we're about to suffer this irreparable harm and we didn't have time to go and pursue some other channel of resolution. And I think that's a fair argument to be made. I'm just trying to think of the potential dollars and fans that Prodigy is likely to lose by making this dispute resolution play out in such a public way. Is this likely to make trouble for Gannon? I don't think so in terms of reputation. There's examples of players standing up to manufacturers in the past, but perhaps nothing on this scale. I think it was only a matter of time. If you've been watching our videos, it's not going to come as a surprise to you. We've been predicting something like this now for about 2 years. I think it was time for there to be a visible, public example of a player standing up to a manufacturer this way. Is this going to make it difficult for Prodigy to sign other pro players in the future? Do players want to sign with a company that has a track record of suing their players? I think that's a real problem. How big of a problem, I guess, remains to be seen. At the risk of sounding self-serving, I hope this is a lesson for companies and players out there. The dollars are big enough now, you can't mess around with these contracts. There's a lot of great lawyers, there's a lot of great law firms out there. Please, I know legal services are expensive, but this is your business or this is your career that we're talking about. Spending a little bit of money on the front end to make sure that your contract is done correctly might save lots of dollars and headache down the road, because I suspect this is not the last time that we're going to see a player and a manufacturer involved in a legal battle with each other. So of course, as always, I'm curious to hear your thoughts. I'd love to hear what you think in the comments. Is Prodigy at fault? Is Gannon at fault? Do they share responsibility? What does this mean for the future of Prodigy? What does this mean for the future of Gannon Buhr? What does this mean for the future of our sport? Like, follow, subscribe. Let me know your thoughts in the comments. Thanks.